Welcome to ACA's Family Forum on Supported Decision-Making. Supported decision-making is widely recognized as a less restrictive alternative to guardianship. Supported decision-making allows people with intellectual and developmental disabilities to make their own decisions with the support of trusted persons in their lives. Naomi Brickle is here, and she is the Project Director for Supported Decision-Making New York, leading the effort to develop an infrastructure for supported decision-making facilitation services and agreements as legally recognizable alternatives to guardianship. She previously worked at the Westchester Institute for Human Development, working with young adults to promote their self-determination and empowerment. Naomi has also personal experience as she, along with her daughter, is in the process of creating a supported decision-making agreement. So with that, I will turn the presentation over to Naomi. Welcome, Naomi. You're on mute.
Yeah, thank you. Thanks, Pam. Thank you for the intro, and let me share my screen. Oh, so I lost you guys here. Let's see. All right. So you're seeing.
We got it.
Okay, great. So thank you for taking the time to tonight to join us while I share information about Supported Decision-Making New York and our supported decision-making effort here in New York State. As Pam mentioned, I'm Naomi Brickle. I'm the Project Director for Supported Decision-Making New York, and we're housed at Hunter College, currently funded by OPWDD to develop a statewide infrastructure so that individuals who want to create supported decision-making agreements can do so. So it's a really exciting effort in light of the legislation that was passed in July of 2022. And I'm thrilled to have opportunities like this to share information about the project so that more people know and more people come to understand what exactly supported decision-making is, as well as the implications of a sort of supported decision-making agreement for an individual. And it's pretty cool. So I wanted to just start by giving us some context. As a mom, as Pam mentioned, I'm a mom of a 26-year-old daughter. And when I was first kind of introduced to this initiative issue, I kind of saw it in more practical terms than philosophical terms. And I saw it as kind of almost just one tool in the toolbox on a continuum of alternatives to guardianship. So we would have guardianship, supported decision-making, and other alternatives, such as healthcare proxies and powers of attorneys and things like that. I almost kind of perceived it as like a guardianship light. And it's not that at all. And in order to just drive that home, I want to spend just a little bit of time talking about legal personhood and what that really means, and giving us context so that as I move forward and explain the project, you'll really have a sense of why it's important and why it's important for either you as an individual or for your family member that you love. So let's start. I want to start just by asking everybody to think about their own personhood. I want each of you to think about one noun that describes who you are as a person, not an adjective, not nice, not funny, not smart, but a noun like a mom, or a noun like doctor, or a noun like teacher, or a noun like student. Any noun that comes to mind that describes that represents you and that you identify as that noun. I'll give you a second to think about it. And now I want you to ask yourself something. When you think about that noun and that noun seat that you are occupying, did your mom or dad create that for you? Did your mom or dad put you, or your family member or your legal guardian, put you in that noun seat? Or did you create that noun for yourself through decisions and choices that you've made in your life. And I would bet, maybe with the exception of student, if you're an elementary school student or a high school student, if you're any other type of student or any other type of noun, I would bet that in the majority of cases, that noun is the result and the representation of decisions that you've made to create that noun. Decisions you've made to define your life's course and who you want it to be, and to decide on your identity. And that's a really big deal. Can you imagine if you didn't have that opportunity to make those decisions, to create your noun? And that's really what we're talking about and what's at stake here when we're talking about guardianship, especially here in New York State, where 17A guardianship is such as that's specifically geared to our population of people with intellectual and developmental disabilities, is really one of the most restrictive. It's something called plenary, and it's one of the most restrictive guardianship laws in the country. But let's talk a little bit about guardianship, and let's give this a little context. So whereas guardianship is a legal process whereby the rights of an individual to make decisions about their life is taken from one person and given to another, supported decision making is not guardianship light, but it's actually a process whereby a structure of support is established. A group of people are defined to provide support in decision making so that the individual can retain the right and be able to make those decisions themselves. Here in New York, we have two guardianship laws, and I think it's important to kind of spend a little time on them to really understand why I just made that statement, that 17A guardianship, the guardianship that we as parents would be petitioning the court for on behalf of our individuals, our children, or our loved ones, if we were to pursue guardianship. So here in New York, there's two types: Article 81 guardianship and 17A guardianship. 17A guardianship is specifically for individuals with intellectual and developmental disabilities. And there's some important differences between Article 81 guardianship and Article 17A guardianship. Under Article 81 guardianship, you actually, you have to have an attorney. You need an attorney to go to the court, but the individual who let's say Article 81 guardianship is often used in cases where, let's say, for an elderly parent or somebody who's had an accident, who people surrounding them are concerned about their ability to make decisions and to either make decisions and or require protections around in certain areas of their lives. But in Article 81 guardianship, the individual who's being considered for those to have that guardianship, to be under that guardianship, also has the right to an attorney. So not only does the family themselves who are seeking, or the people who are seeking the guardianship, need an attorney to get it, but the individual themselves has a right to an attorney. The individual has a right to be notified and to have a copy of the petition. The individual has a right to be present in 81 guardianship. None of these are true for 17A guardianship. So when we're talking about 17A guardianship, when a parent or a family member goes to petition a surrogate court for 17A guardianship, the individual doesn't even need to be notified. The individual doesn't need to be present, and the individual doesn't necessarily have any rights to recourse or protection. Another important distinction between Article 81 guardianship and 17A guardianship. 17A guardianship is something called plenary guardianship, which means it's everything. It's all or nothing. It's guardianship of the person and guardianship of the property. Whereas Article 81 guardianship can be tailored and specific to just certain areas of an individual's life and decision making, based on that person's functional capacity and or the needs for support in different areas of their life. In addition, there's no accounting required for 17A guardianship. So in many states, guardianship, there's not two guardianship laws. And if there are, there is a yearly accounting required. So under Article 81 guardianship, the guardians actually have to go back to the court every year and detail how they've implemented the guardianship, what they've done, how they protected. They're accountable to the court. Under 17A guardianship, once that guardianship is in place, it's just there. There's no requirement for a guardian to go back to talk about how they're protecting, to be accountable to the court for that individual. And what's really important is that it creates a legal limbo. So let's say a guardianship, a guardian in a 17A guardian passes away. There's a real confusion over what happens to that guardianship for the individual if something's not, if somebody doesn't take the initiative to go and address it. So really important distinctions, and important to understand that Article 17A guardianship does not offer any rights or protections to the individual who will lose all of their rights. Now, let's face it. I'm a mom. I think a lot of people here tonight are probably parents, and in the majority of cases, everything I just spoke about is not necessarily an issue, right? Because even if I was to have guardianship of my daughter, which I don't, I have my daughter's best interest. So my motivation to seek guardianship on behalf of my daughter would not come from being able to rule her life necessarily, but be much more about protection. And that is in the majority of cases, and probably I would say almost every case, it's that protection, which is why parents seek 17A guardianship. But let's get a little more context. So why is it that here in New York State, we have the most restrictive guardianship law, perhaps in the country and perhaps in the world? Why would such a progressive state, a state with one of the most, as much as we as parents might feel frustration at our DD system, I've done a lot of work professionally in other states. We actually have a really good DD system. In other states, services and access to services is much more difficult than the access we have in New York. So despite our frustrations often with the adult system, especially after coming out of the special education system, which is more focused around entitlement, our DD system is actually a very generous system compared to other states. And we are known as a progressive state. So how did guardianship, how do we get here? How did we get to a place where we passed such a significant human rights law, a law that would seem to contrast human rights philosophy? Part of how we got here is the fact that New York was very progressive at the time at the time of deinstitutionalization. We were very ahead of other states in deinstitutionalizing individuals and bringing individuals into the community. Our group home system at the time, while it's now feels very old and traditional and perhaps outdated, at the time it was developed, we were leading the nation in that. So many other states were very slow to come to deinstitutionalization in the way we did. What that led to, though, was a lot of individuals living in the community and families who were concerned about their potential to exploit, their potential risks for exploitation. So New York also happens to be very well known for our strong advocacy amongst families of individuals with disabilities. And that advocacy is what led to our 17A guardianship. Families fought, families advocated for protection of their individuals. And so we created this type of of guardianship that wouldn't require attorneys, that wouldn't be expensive. And it came from good, it came from protection. But with that, and now, years and years later, probably, I think it's probably 50 years later, we are left with what can feel like an outdated and overly restrictive law. Supported decision-making is not simply a New York response to that law or a guardianship light for New York, but it's really comes from an international movement. It came out of a disability rights movement and a shift from a medical perspective around disability to a social model of disability. So what does that mean? Well, it means that instead of seeing disability as a fault, as a medical issue, as a medical mistake, or as a medical insult from an individual, disability has evolved to be perceived as just another type of diversity. So that's one place where it comes from. The second place the supported decision-making comes from is really just the Universal Declaration of Human Rights, 1948, when all of the countries in the world came together after the atrocities of World War II and developed the Declaration of Human Rights. And one of the very important basic human rights that was established, that was agreed upon by every country, was the right to legal recognition before the law, legal personhood, and that recognition. In 2006, inspired by leadership of U.S. leadership, in fact, in addition to the Declaration of Human Rights, a convention was added where that was focused around people with disabilities. So it's almost like another section was added that focused on the rights, the basic human rights of people with disabilities. And this passed in 2006. It was ratified by most of the countries in the world. Ironically, while it came to be because of leadership through from the U.S. And U.S. academics and U.S. advocates, we are one of, I believe, only 2 countries in the world who have not ratified the CRPD. So this is not a New York thing. The right to legal personhood and recognition before the law was a very significant piece of the CRPD, as it's called, the acronym, the Convention on the Rights of People with Disabilities. And in addition to simply being one of the core principles of the CRPD, the kind of acknowledgement that a basic human right is the right to make decisions about your life is included, and this right to decision making is threaded throughout. But it's really I share this slide because it really, the main points I think really jump out here, and that is the right to have recognition before the law, the right to recognize that people with disabilities deserve that same recognition. But that point 3, which is what I think is the most important piece of where supported decision-making came through, is the recognition that people with disabilities are not different in having a right to legal personhood and legal recognition, but may require different supports in exercising that right. And so that's where supported decision-making and why it's an international movement. And to bring you just some more context of where we are in this worldwide movement. Last summer, the Mexican Supreme Court ruled that declared that guardianship was unconstitutional and required states to go back and make new laws, the states in Mexico to create laws that to update their laws to acknowledge this. So like I said, it's an international movement. In 2016, Judge Glenn, who was the quote on that first slide that I started with about personhood, founded this project, which has from its inception been called SDMNY. It was funded by the Developmental Disabilities Planning Council. Judge Glenn had previously been a surrogate judge and surrogate court is where 17A guardianships are granted. And she was a huge human rights advocate. She was a passionate human rights advocate. But what she saw was that individuals were coming to her court, families were coming to get guardianship for their individuals, and she saw individuals who she believed, in her opinion, had the ability to make decisions in their lives. And really, it was struck her how significant the plenary nature of 17A guardianship was for these individuals, because she knew that if she was to grant that guardianship, these individuals, who in many cases did have capacity to make certain decisions about their lives, lost all rights to do so. So she is a passionate, determined woman, and she got funding to launch a project here in New York State from the New York State Developmental Disabilities Planning Council. And she got 5 years of funding to raise awareness, develop a process, to try and make a evidentiary base for a law, and to kind of create a plan for how to make this happen in New York State. And I put on the slide that this project was the largest project in the U.S. and the second largest project in the law. And to drive home just how recognized SDMNY is as a leader in this movement, at the end of September, we had the representatives from Israel's Ministry of Justice, just days before the war began there, came and visited our project to hear more about how we were implementing certain components of our law. So where we've come, well, we're at a place now where many people, like in 2016, I hadn't heard of supported decision-making before. I was invited to be on the advisory committee for the project because of the work I was doing in other areas around self-determination. But we've now widely recognized by families, many families, that's why I assume you're here tonight, have heard of supported decision-making, have heard of it as an alternative to guardianship. Many self-advocates, it's a big initiative for SANIs, the Self-Advocates of New York State group, and the courts have heard about it. More and more judges are now acknowledging supported decision-making as a less restrictive alternative to guardianship. Judges are required by case law before granting guardianship to consider if there's a less restrictive alternative that could be appropriate. And more surrogate judges around New York State are not granting petitions for guardianship because of the existence of supported decision-making. We've developed a process of facilitation, and I will say that our facilitation process that's now built into our law is unique to any other project or any other movement or any other state's process. We're the only state with a facilitation process built in, and I'll explain shortly why that's important. SDMNY we're now operating on under a grant from OPWDD to create a statewide infrastructure. And most importantly, we now have a law. So Judge Klun was incredibly, and the individuals who are working on this project were incredibly and quickly very effective in not only developing a process, developing protocols, but to get a law passed that recognized supported decision-making agreements as legally recognizable alternatives to guardianship. I'll leave this out, but it's just, I won't comment too much on this, but just to drive home the point that more judges are, again, refusing or even acknowledging supported decision-making as an alternative to guardianship. So I wanted to just, here we are now in a state with a law, a statute that is not yet in effect. It will be in effect when the regulations are finalized. But in a state with a law that recognizes supported decision-making as a legal recognition to guardianship. And I put this language here. This is the language right up front in the findings and purpose, because I really think it's the language that's included really does in my opinion, capture the human rights impact of guardianship and of supported decision making, and really does drive home the fact that people with disabilities are no different than anyone else in the need for support in making decisions. We all utilize support in making decisions, and just by nature of the disability should not and the outdated stigmas around disability should not lose their rights to be recognized before the law. Some important components, some important just points about the law. First of all, the law recognizes supported decision-making, both formalized through an agreement as well as informal supported decision-making, as a less restrictive alternative to guardianship that judges should consider before imposing 17A guardianships. It prevents discrimination by requiring that third parties accept decisions made by people with supported decision-making agreements made according to the terms of the statute. So I'll talk a little bit more about that, but agreements that are made through SDMNY's facilitation process and signed by facilitators who have been trained by SDMNY and operating in alignment under the supervision of supported decision-making New York, agreements made within those process and protocols are legally recognizable alternatives to guardianship, and third parties are required to recognize that. So in other words, if an individual goes to a doctor and has medical decisions in their supported decision-making agreement, a doctor, and is utilizing the supports that are detailed around that area, a doctor can't say to that individual, or can't say, I'm not going to serve you because you don't have the capacity to make decisions. It also incentivizes, I spoke about this already, but it incentivizes the courts and families to consider supported decision-making as an alternative to guardianship. And as I already pointed out, it also requires a facilitation process that ensures their understanding. And I'll talk a little bit more about why that's so important. So as I mentioned already, supported decision-making can take many forms. It can be completely informal, the way any of us uses support in decision-making. None of us goes and buys a car without talking to someone, even if it's a car dealer. Nobody makes important decisions about their health or about whether to have a surgery per se without consulting the doctor, but perhaps also Dr. Google or a family member as they're making decisions about whether or not to have a potential surgery. It can also be informal, but with a written agreement. So, as any agreements right now, before our statute is finalized and in place, would be considered informal because they're not recognized by statute, but they are written agreements with a detailed structure of support for the individual to utilize when making important decisions in certain areas. We then have, obviously then, because of our statute, agreements that are recognized, that are created according to the terms of the statute, and then recognized, required for third parties to recognize them. So let's talk a little bit about our process, so that as I go forward and talk about the protocols we use to create these agreements, you'll have some understanding. So first of all, in supported decision-making in our process, individuals with intellectual and developmental disabilities who seek to create the agreements are referred to as decision makers. And when decision makers create agreements within our process, they detail what are the decision-making areas and types of support they would want in those areas, as well as who will help them make those decisions. So they define the areas, the types of support they want, and the people who will help them. The decision maker and the chosen supporters work with the SDMNY facilitator to develop a supported decision-making agreement, or SDMA. And that facilitator actually signs the agreement and will help them understand the process, understand the different, work with the individual themselves to understand decision making, what goes into decision making, kind of go through almost a theoretical framework around decision making, as well as talk about social network theory, but again, in more practical, not theoretical terms, so that the individual kind of breaks down decision making, is more thoughtful and intentional about their decision making, and can be more intentional about selecting the right people who can be supporters in their lives. Important, and this is something that's a difference, a really important distinction between guardianship and supported decision making, is that the participation in our process is voluntary, and the decision maker has to be engaged, involved, and driving the process. The decision maker does have a right to leave the process, to change or terminate the agreement they create, and or to use or not use the agreement. But the supporters cannot change the agreement. So here's just a kind of diagram that kind of explains our process. So at the center, of course, is the decision maker. Around the decision maker are the chosen supporters. The facilitator works with all of them to create the agreement, to help them navigate the process to create the agreement. And the facilitator works under the supervision of our supported decision-making New York mentors. So our own staff who are expert in our process, and work with facilitators to kind of guide them as they guide the individual and their chosen supporters through the process to create an agreement. In the first phase, the facilitators work with the decision maker. In the second phase, they work with the chosen supporters. And in the third phase, they all come together to negotiate the terms of the agreement. So phase one, as I mentioned, is when the facilitator is working directly with the individual themselves to kind of help them understand decision making, to unpack the steps that go into decision making, and map out future decisions and the steps that might go into that, and identify in those kind of decisions what are the types of support and who are the people who they think would be good people to choose in those areas for their supporters. An important piece of phase one is really working with the individual to empower them to understand and be more intentional about their decision making, to be less impulsive and more intentional about decision making. A big component is that empowerment. A big piece of what comes out of phase one is that the individual realizes that they're not that different. It generalizes the fact that they're not that different from everybody else in the need for support in big decisions. And I just realized that last bullet I was supposed to take out, but again, phase one is really about the work with the decision. At the end of phase one, a decision maker will have developed kind of a draft of their future supported decision-making agreement. They will have thought about the areas in their life where they want support, the types of support they want in those as they're making decisions in those areas, as well as the people in their life who might make good supporters in each of those areas. In phase two, we work directly with the chosen supporters. So we do outreach, the facilitator and or the decision maker, based on what the decision maker's desires, they reach out to the chosen supporters, and the supporters are educated about supported decision making, about our process, about the law, and about their role as a supporter, and their role not to impose their own decisions on the decision maker, but to truly be a supporter for the individual so that they can make the decisions themselves. In this phase, we do a lot of work repositioning from a role of a mom or a parent to a role of a supporter, a person who's in the role of trying to assist with the empowering the individual to be the decision maker in their own lives. And phase 3 is where people come back together, where the decision maker, their chosen supporters come back together to negotiate the agreement and the terms, to come to agreement about the areas of support and the types of support that the supporters will provide. So it may the agreement that comes out at the end of phase 3 may look very different from that draft agreement that was developed at the end of phase 1. As there's more discussion, perhaps a potential supporter doesn't feel comfortable providing the type of support that was first envisioned by the decision maker. So there's a lot of discussion, and very frequently the agreement that comes out at the end is a very different agreement than the one that was kind of drafted in phase 1 after discussion and thought and conversation and consensus between everybody. And finally, a celebration when they sign the actual agreement. So what are the end products of our facilitation process? Well, of course, besides the agreement itself, it is a fluid document. It's a fluid structure around the individual that the person can use as they make decisions in their lives. It's a document that is developed and designed to be changed as the individual grows, as decisions in their lives change, as important decisions that they make in their lives may change, as people come and go in their lives. So it is a document that's fluid and that can be changed after the facilitation process. A big piece, and we now have an evaluation that's confirmed that a big component, a big result of our facilitation process is enhanced self-determination and empowerment, and change relationships between the decision maker and their supporters. We've had a lot of families say how powerful the process was in helping them see their child as an adult and as a decision maker in their own life. So let me talk a little bit about our grant so that you kind of get where we where and how of supported decision making in New York. So we've been funded by OPWDD to create an infrastructure for New York so that everybody who wants to make an agreement can do so. So we are working with we are working with agencies across the state, including care coordination organizations like yours. That's why I'm here tonight, to develop partners to provide facilitation. So we are actually training staff in all of these organizations and these care management organizations to provide facilitation services under our umbrella. We're also training attorneys, so we have some attorneys who are also providing facilitation services within their practice to on behalf of the individuals and their families who come to them to do advanced planning. Another big piece of what we're developing is just a TA and mentoring network. So we are creating a technical assistance center to ensure the quality of the facilitation process in the state, so that agreements that are made are truly and maintain their credibility and recognition under the law. We're also doing a lot of education and outreach. It is my goal that at the end of this pilot funding, that everyone in New York State will see supported decision making as the default rather than see guardianship as its default. And another big piece of our grant is about is an evaluation to ensure that our processes and protocols that are in place ensure quality agreements and agreements that retain their legal recognition. So our big goals are high quality facilitation, technical assistance to ensure that individuals that have access to supported decision making, no matter which services they're using in the OPWD system. We're doing a lot of outreach and education. And the biggest thing we're doing is trying to create systems to make this work. So contracting for the resources and creating administrative processes. So some important goals where we're at and looking forward, we now have a regular calendar of training and events. We are doing a lot of trying to engage the private bar as well as the courts. We're training, worked on our curriculums and our training of facilitators and created materials where we're in the process of creating materials for supporters so that when supporters agree to participate, they really understand their role and they have resources to ensure that they do so, especially after the fact for new supporters that may come on. And one of the big pieces that we're also working on is really just engaging self-advocates in our project so that what we create really represents a meaningful process and protocol for self-advocates, that our resources are accessible, that our process is accessible to individuals. So I want to open this up to questions before we end, but I'm going to just maybe suggest you take a picture of this slide or actually I know we're sending out the slides, but the QR code is how you can access our contact us page. I would highly recommend you get that link, the sdmny.org. That's our website. We have a great website. We continue to update it. It's got great resources. Everything I talked about tonight is detailed in resources or content on our website. So I highly recommend that you go there. Pam, I'm going to defer to you on whether I'm going to stop sharing now, but I'm going to defer to you on whether we share the video or we open up for questions.
Let's make sure that we get the questions in. There's not many, but I want to at least we can send the link to the video tomorrow. So
Perfect.
I would say let's just
before we move on to the questions, though, I just want to really emphasize that the video that she'll share, I highly recommend you watch it. It's a video. It's a testimony by a parent whose child went through the process and really speaks to a lot of the changed relationship, the empowerment of the individual, and why it was important for her as a parent, both before and after, even more after the process. So highly recommend you take the time. It's a 3-minute video to watch that.
Okay. All right. First question we have. Let's see. Well, I see the flaws of guardianship and would like support decision-making for my son. I worry that the interpretation would have its own issues and gray areas.
Worry that what? Sorry, I missed it. Let me see.
You want me to start? Okay. Well, I see the flaws of guardianship and would like supported decision-making for my son. I worry that the interpretation would have its own issues and gray areas. My son will have no blood relatives after we pass, no siblings, no relatives in New York.
Well, that's a complicated whether you have guardianship or not. But I will say a big piece of our facilitation process is a very mindful and intentional selection of supporters who will be able to provide support. And for me as a parent, what I've found very meaningful in this process is how deliberate it's been about shifting from me as the primary supporter to an exploration of who else can provide support. So whereas my daughter is more than happy to default to my decision making and for me to be the go-to, as she's gone through this process, one of the areas that came up was where she's going to live. And in the conversations about where she was going to live, the facilitator, as she was working with her, I don't know what she asked her because I wasn't there, but my daughter happened to speak up and say, oh, my cousin is a real estate person, so maybe she could be a supporter for that. Now, that was so organic, and the cousin has not been asked yet because we're not there in the process yet. But one thing I know is that when that cousin is asked by her cousin, how that can she, is asked to be that, provide that, be that person in her life, I am not at all hesitant that she will not only say yes, but that she will feel really good for having been asked, and will be a great supporter in that area. So the dilemmas of the what's going to happen after I'm gone question that every one of us as parents lose sleep over is not solved by supported decision making, and nor is it solved by guardianship. But while supported decision making is not the answer to that fear and that question, supported decision making is an answer to that fear and that question. It's one piece in the puzzle that I think can provide just a little bit towards that. The other thing I just want to say about guardianship, you know, so many of us, myself included, are advised by schools or the people, professionals in our lives to get guardianship as a protection for an individual. What I've really learned in the almost a year now that I've been working closely in this project is how much guardianship is not a protection, does not provide the protection that we as parents may perceive it to be. It does not protect your individual from being exploited on the dark web. It does not protect your individual from getting into a bad relationship with an individual. But our facilitation process, at the very least, does walk an individual through more mindful, a more mindful and intentional decision making, and a process where they really become thoughtful about who are people that I can reach out to when I do need to make these decisions. And guardianship doesn't do that. Guardianship, nobody knows. Most individuals don't even know they are under guardianship, or if they are, they don't really understand the implications. But it certainly isn't a thoughtful process. And when they do get in trouble, a parent does have a right to go to a court to enforce a guardianship. Perhaps if a person gets into a contractual relationship that where they're being financially just at a disadvantage. But to go to the court, you need an attorney, and that's not cheap either. So I think so many of us are told, guardianship's going to protect, but I don't necessarily believe it. Actually, I do not believe it provides protections that so many of us are led to believe.
Thank you, Naomi. Next question. What would the situation under supported decision-making New York regulations be for individuals that are severely disabled intellectually and nonverbal?
That's a great question. I'm very glad it was asked. What makes New York statute different than any other state? So there's currently 22 states that have some form of acknowledgement of supported decision-making, whether it's even just funding to initiate a movement. But several states do actually have supported decision-making agreement laws, where much of it is similar to New York. But one thing that makes New York totally unique to any other. So in these states where there's similarities, the similarities might be like who can be a supporter and who can't, and what can a supporter do and what they can't. The fact that a supporter can impose decision-making and can't be abusive. There's certain similarities amongst the laws and the roles of supporters and the roles of the decision maker and that legal capacity of the decision maker. New York is the only place that requires a facilitation process in our law. And in order to participate in that facilitation process, it has to be voluntary. The individual has to actually participate. So whereas in another state, an agreement could simply be signed with no understanding on the part of the individual of what they were signing, in New York, that's not possible because the individual actually has to have the capacity to go through the process to create the agreement. They have to have the capacity to describe, even with accommodation. So we have worked with individuals who are nonverbal, but they did have the capacity to communicate their preferences around the areas of decision making in their life, the types of supports they want, and the individuals they want to support them. So our process is not for everybody. It does necessitate a certain level of capacity to participate. So in that regard, our advocacy is not to ban or outlaw or say all 17A guardianship is wrong. We truly do acknowledge there is a place for people where guardianship is appropriate for an individual. And I would suggest that it is appropriate for an individual who doesn't have the capacity to participate in our process. That said, we do not have an assessment to sign up for a process. Anybody who wants to participate can. But when they're in our process, they must actually be able, willing to communicate their preferences and, the details of their agreement. So great question. Thank you.
I'm just going to go out of order because I want to highlight Betsy. She's been commenting quite a bit. She's an attorney from Ohio. And Betsy, feel free to unmute yourself if you like. But Betsy said, true for us too, that we were encouraged by institutions and including educators and Medicaid-related agencies to go for 17A guardianship. So I think that's,
that's absolutely
to your point.
Every school, I don't know, but everyone who's a parent here, when your child was in high school, how many of you got a checklist that said, that you had to do at certain ages, apply for OPWDD, sign up for Access VR, your Social Security benefits, guardianship. I remember on one of them was said, register for the draft. These things that we're all told to do. And, so many parents I've talked to, more friends of mine, when it's actually friends from other states that I'm thinking of right now, who've said, oh, but the school told me guardianship's what my daughter has to do. And I yeah, they told me that too. And so there are other alternatives. And, one of our big priorities right now is to educate the educators. And I do see that there's someone just made a comment about District 75. We are connected with District 75, and we really do. We are looking to get the word out. So as much as all of you can help us, I appreciate that as well, and I'm open to that.
Thank you.
Open to outreach is what I mean to say.
All right, next question. This sounds like this leads to a formal document as opposed to the informal support. Who carries and uses this document?
Great question. It does lead to a formal document. It's notarized and/or signed by two witnesses, and it is legally recognizable. So yes, it's formal. So I would just say that the individual keeps a copy. And/or their family. We keep a copy, so there will be copies in our system, so that should an individual lose it, they can get a new copy. But it is something that the individual should have, because there's actually a page that they can use and print when they are challenged by a third party. And they can say, this is my agreement, and once the law is finalized, our template will also detail why the third party has to recognize, and gives where the individual can sign an attestation that they are utilizing the agreement, the supports in the agreement, and so the decision must be recognized.
Okay, great. A quick question on: do you pay any members of the supported decision-making team?
Do we pay?
Yes.
Okay, so the people who are paid in this process are the people who provide facilitation services. Supporters are not paid. Sometimes supporters are staff. We've had individuals who live in certified residences who have selected staff as their supporters, and whether or not they, how that support is reimbursed or not is completely, based on the agency they work for. But we do not pay individuals or supporters for their participation. And decision makers do not pay supporters to provide support. But we are funded to pay the facilitators to reimburse them for their time spent with the individuals and their supporters developing an agreement.
Okay, next question. What happens in most states where supported decision-making is not recognized?
Well, I'll say that even in states that do not have supported decision-making legislation, every state, to my knowledge, has a supported decision-making initiative, because there are networks, there developmental disabilities advocacy networks in every state. Like we have our New York State Developmental Disabilities Planning Council, and we have every state has a University Center for Excellence on Developmental Disabilities, which is a center for best practice at a higher ed institute of higher ed. Almost every one of the USEDs and/or developmental disabilities planning or councils on developmental disabilities, are either funding a project or have an initiative. So every state has a conversation going on, and even in states that don't have legislation, just like New York, we didn't have legislation till July of 2022, but courts were still saying, please, to families, I'm not going to provide, grant this petition for guardianship because a supported decision-making agreement might be a better process. So even prior to New York's law, judges were still refusing petitions for guardianship in cases where they thought that a less formal supported decision-making process could be considered less restrictive.
Okay, there's a question about how to reach you, Naomi, and
so that slide is a way to reach us. I'm happy to put my let me see. I have to.
It's in the PowerPoint though.
Oh,
right?
it's in the PowerPoint, right? So my email's in the PowerPoint, so you can feel free to reach me.
Mm-hmm. Okay, another comment about 17A. Felt wrong even when we were encouraged by the school. Common.
I appreciate that comment because it always felt wrong to me, even when I wasn't connected with this. It just felt very restrictive.
So
especially, I'm just going to make a comment too. My daughter happens to use self-direction, and I think it would be kind of ironic for an individual under self-direction to not have a right to make decisions. Like the irony there is even though I can say, of course, my daughter's self-direction is mom direction, but the premise of self-direction to have an individual who utilizes self-directed services also have a 17A guardianship almost seems to be conflicting.
So a quick question on so paid support for supported decision making could be ComHab workers or SEMP workers, for example.
Yes, there have been cases where we've had ComHab workers that are also served as supporters. Again, that's more of a protocol and like an agency. That would be on agency case by case basis and what their protocols and policies are.
That is the end of the questions that are in the chat box. Does anybody want to ask any questions directly to Naomi?
Can I ask? I just typed in something. Can you hear me?
Sure.
Yes.
No, about paying. I mean, I know that the facilitators get trained and obviously would need to be paid because they are working, for the group. And the supporters, I see supporters as being people who already know the individual, so they're kind of friends or whatever. But my question is, does the individual or family pay for the whole 6 to 9 month process, the setup of the documentation? I'm told it's a long process.
It is a long process because it really is a process where the individual themselves has to develop the terms of the agreement, so that there really has to be the facilitator needs to ensure that there's understanding of what they're doing. And again, that's what makes our law in New York so important and meaningful, because it really does require meaningful understanding and participation. And that can take a while. And it can take a while just to build the rapport between an individual and the facilitator, and which was absolutely the case in my daughter when she was working with her facilitator. It took a long time for her to be comfortable and for her to participate even. So yes, it is a long process, but the family, the individual does not pay for it as of right now until the duration of our OPWD funding. This service is free.
Okay. Thank you.
Yeah.
Naomi.
So
Go ahead. Artie.
Yeah. So context to that, I understand that the lawyer fees and all that stuff included in the OPWDD stuff, or individually we need to pay for the lawyer fees.
There's no lawyer fees with supported decision making.
Okay. And another thing is, my child is of 16 year of age, so we should wait up to 18 year, or we should proceed for right now?
I didn't hear you. Went out for a second for me.
My child is 16-year-old, so should I
Okay.
wait up to 18 year, or should I start processing for the same?
So because of the nature, because it is a legal document, an individual can't sign the document and have it be effective until they're 18. So we don't typically do facilitation with people under 17, and we usually won't start facilitation with people even under 17 and a half, because there's no point to go through the process if they can't legally sign. You can't legally sign a document until you're 18 years old, whether you have a disability or not. So I would recommend, starting right around 18. I found them to be the process to be more effective even later. But there's, for families and or individuals who are eager to create an agreement and have one in place when the individual turns 18, there's nothing that prevents you from participating in that process, like joining the process, signing up, so that the individual can go through. And like I said, it's a fluid document. So as people, as life circumstance changes and the types of decisions your son might be making in his life change, the document can be updated as well.
Okay, two more quick questions. Can private counsel facilitate this and craft the agreement?
Yes and no. So yes, we have attorneys who are trained and are in an agreement with us and work under us. So they are authorized under SDMNY to provide facilitation services. And in those cases, they can. But in order for an attorney to create an agreement that's considered legally recognizable, it has to be they have to be under SDMNY's in contract or connected with us, because the law requires that the facilitator's signature on an agreement be signed by a facilitator authorized by OPWDD. And in order to be a facilitator that's authorized by OPWDD, you have to be under the SDMNY. So if the attorney was one of the attorneys who's trained by us and working with us, then it would be. But otherwise, it's not technically legally recognizable. That said, as I mentioned, the law does recognize even informal agreements as less restrictive alternatives to guardianship. The issue with that is just that the law does not grant the protections for third parties. The third party protections are only for agreements that align with our process and are signed by OPW authorized facilitators.
And also on the same line, same person's asking, do you have a list of the private attorneys who could do this? But I think you answered that question, that they have to go through that, process.
Yeah, I could share that with you privately if you reached out to me.
So again, and just for the person who asked that, you can also reach out to me and I can connect you to Naomi too. So I put my information in the chat as well to make it easy for everybody. Some other quick questions. Is there a waiting list? My son turns 18 in 2024.
No, I won't. Yes and no. There's not a waiting list. But what we do is we have people sign up, and then they're assigned when we do our trainings for our facilitators. So it's possible that we have an available facilitator right now, but it's possible that you may be assigned after our next training in January.
Do you have time for two more questions?
Yeah.
You okay? Okay.
Yeah.
Let's see. So are all the conversations between facilitators by phone?
They're by Zoom. So I would say 99% or 98% of our facilitation process happens over Zoom. In some rare cases, there are individuals who really aren't comfortable on Zoom. What we found is when we went to Zoom, it used to be all in person, but during COVID, when we went to Zoom, it was far more preferable for most of the decision makers in our process. So in the majority of cases, we do it over Zoom or FaceTime, like my daughter, I think, is doing it over FaceTime with hers, and or sometimes even the phone. But in some rare cases, when individuals really would prefer in person, we've done that as well. As long as there's a facilitator in the region where they live, where most of those that we've done so far have been in New York City, where we have a ton of facilitators.
Okay. Can I, as an out-of-state sister, be the supportive decision maker?
Yes.
Okay. And then final question we'll do for the night. What would you say is the benefit of supported decision making over just getting power of attorney in certain areas of concern, say health and money matters, renting, banking, hospital consents, etc.?
That is a great question, and I'm going to give you my mom. I would say the company answer would say supported decision making is better, but the mom answer, I'm answering you as a mom in this situation, is both. I would say this goes very well with when accompanied by those. So currently we're in the process right now of developing some of those documents right now with my daughter, as well as a supported decision making agreement, and they definitely work well together.